Good evening. Good evening. Good evening. Good evening. Good evening. Am I audible? Good evening. Am I audible? Just give me a minute. There is a problem. My other phone is not signing in. Good evening. Good evening. So, those of you who have attended the exam today, how was your exam? I'll just be back in a minute. Okay, now I am back. That's good. That's very good to hear that you have attempted all the questions. That's amazing. Just a second, huh? Actually, today I am not in my city, so I have to arrange stuffs a little bit before I can start the class. I mean, I did not think I'll need all of those. So, excited to write your law exam? Huh? Excited to write your law exam? Are you? Just this much, you let me know. Are you excited to write your law exams or not? Good evening. Good evening, all of you. Good evening to each and every one of you who has wished me good evening. Good evening, good evening, good evening, good evening. So, I will just make myself also visible here. So, am I visible? I am visible, I guess. Yes. Good evening, everyone. I know. And that is the reason I think that today class would be best for you all because you are exhausted. You cannot study too much. So attending today's session would just do a revision of the whole of the Indian Contract Act. So it would be kind of a revision for you all. So that is the reason I decided to take the session so late in the night today. So let me put it somewhere where I can see it. Now it's perfect. So let's move on with the class today. Don't want to waste your time because time is very precious right now for you all. So today we had already covered all the scanners of all the other chapters. Only one chapter was left, that was Indian Contract Act. And so today we are going to cover Indian Contract Act in our sessions. Okay. So today in this session we are going to cover our Indian Contract Act. So you already know how we generally do the sessions. I'm going to read out the questions. We are going to discuss the answers. And in this, actually, with this whole scanner discussion, you're kind of doing a recap of the entire chapter because almost the whole chapter is covered here. So it will be kind of a quick revision of the entire chapter also for you all. So I'll start with the questions. You already know what does each of the word in the question signify. What does this mean? You all know that. So I'm not going into that. LLP, do you need me to do that, LLP? Ramaswamy proposed to sell his house to Ramanathan. Ramanathan sent his acceptance by post. Next day, Ramanathan sends a telegram withdrawing his acceptance. Now, if I want to withdraw my acceptance, acceptance can be withdrawn or acceptance can be revoked if the revocation letter has not been received. Once the revocation letter has been received, I cannot revoke my acceptance. So, examine the validity of the acceptance if the telegram of revocation was received by Ramaswamy before the letter of acceptance. It was received before the letter of acceptance, so obviously revocation is valid. Now, the telegram and both reach together, so basically it is whichever he reads first. But if you will see in the Institute's book, one thing they have clearly written, if it is a telegram of revocation, if it is a telegram of revocation and telegram and letter of acceptance both reach together, in that case the telegram of revocation is absolute. So revocation is absolute, right? So revocation is absolute. All contracts are agreements, but all agreements are not contracts. Correct. When we talk about the term agreement, agreement is a very huge term. Agreement includes both a social agreement, a domestic agreement, or a legal agreement. Now, a social or a domestic agreement is never a contract, it's just an agreement. But when the agreement becomes legal, then it becomes a contract. So, every contract is an agreement, but every agreement is not a contract. Mr. Joy owns 2 flats in a building. He wanted to sell flat number 101. He wanted to sell flat number 101 to Mr. Roy. Mr. Joy offered to sell his flat number 101 to Mr. Roy, but Mr. Roy thought that Mr. Joy wanted to sell. So basically, he is offering to sell a flat thinking he will sell 101, and Roy, believing it is 102, says yes. Can we say there is no consensus ad idem. Correct? There is no what? There is no consensus ad idem. And since there is no consensus ad idem, the contract is not valid, right? Since there is no consensus ad idem, the contract is not valid. Define offer, explain the essentials of a valid offer. When I say offer, offer is what? Willingness to do or not to do something with a view of obtaining the other person's consent to such acts or abstinence, right? Willingness to do or not to do something with a view of obtaining the other person's consent to such act or abstinence, right? So what are the essentials of a valid offer? I have already told you. Even if you remember the points, you can easily write everything in your own words. So offer must be what? Definite, clear and not vague. Must be made with an intention to create a legal relationship, may be express or implied, and when it is expressed, it may be oral or written, must be communicated, cannot be accepted in ignorance, can be conditional, but must not contain any terms the non-compliance of which would amount to acceptance. And a statement of price, a statement of intention, an invitation to offer is not an offer. Good to see you all are answering. That's so good to see. A shopkeeper displayed a pair of dress in the showroom and a price tag of 2000 was attached to the dress. Price tag is an invitation to offer. Miss Lovely looked at the tag and rushed to the cash counter. She asked the shopkeeper to receive the payment and pack up the dress. The shopkeeper refused to hand over. Since it's an invitation to offer, can the shopkeeper refuse to hand over the goods? Yes, he can. So, the shopkeeper refused to hand over the dress to Miss Lovely in consideration of the price stated in the price tag attached to the dress. Miss Lovely seeks your advice whether she can sue the shopkeeper. No. Royal Red, whoever. When it comes to points, yes, you must explain the points if it is a 7 marks question. Okay? If it is a 7 marks question, you must explain the points. Okay? Not necessarily you need to write all the points, but 7 points you need to write and you need to explain them. Not just the headings. Just the headings are not enough. So can the shopkeeper sue the, can Miss Lovely sue the shopkeeper? No. It was just an invitation to offer. She has no right to sue the shopkeeper. Sambhu Dayal started a self-service system in his shop. Srimati Prakash, it's a self-service, and self-service is again what? Invitation to offer. The previous case, price tag, Harvey versus Fassé, if you remember. Self-service shop, Pharmaceutical Society of Great Britain versus Boot Cash Chemist, if you remember. Srimati Prakash entered the shop, took a basket. Oof. Some days this will not work. Some day it will work super fast. Took a basket and after taking articles of her choice into the basket, reached the cashier for payment. The cashier refuses to accept the price. Can he refuse? Yes. Can Sambhu Dayal be compelled to sell the said articles to Srimati Prakash? No. No. Why not? Yes, absolutely. You can give examples while writing the point, Shrestha. If it is not too much marks, don't waste your time because obviously writing examples also takes time. But yes, you can give examples also. Mr. Asim is a learned advocate. Some of you had asked me that, ma'am, is it okay? I got messages like if I write all the 6 answers, don't waste your time. You won't have that much of time. Write the 5 answers that you know properly. Mr. Asim is a learned advocate. His car was stolen from his house. He gave an advertisement. Advertisement in the newspaper is generally an invitation to offer. Correct? Advertisement in the newspaper is generally an invitation to offer. That he will give a reward. But when it is a reward, it is what? It is an offer. He will give a reward. Who will give the information to the person who will give the information about his car? Mr. Vikram reads the advertisement and on making some efforts got the stolen car and informed Mr. Asim. Mr. Asim found his car but denied giving reward to Mr. Vikram with the words, an advertisement in a newspaper is just an invitation to make an offer and not an offer. Hence, he is not liable. Wow, being a lawyer, he's really definitely putting up some points for law, right? Can we say Mr. Vikram can claim the reward because it's just an offer? Newspaper ads containing a reward is an offer and not an invitation to offer. Correct? Rahul goes to a supermarket to buy a washing machine. He selects a branded washing machine having a price tag of 15,000 after discount. Yeah, correct, Nikita. He was not a bright student like you all, maybe. He was not as bright a student as like you all, you know. After a discount, when I talk about a discount is what? A discount is an invitation to offer. With a discount of 3,000, Rahul reaches the cash counter for making the payment, but the cashier says, "Sorry, sir, the discount was up to yesterday. There is no discount from today, hence, you have to pay 18,000. Tell me, liable to pay 18,000 or 15,000? Liable to pay 18,000 or 15,000? 18,000, 15,000. As for me, he is liable to pay 18,000 because it's just an invitation to offer. And in case of an invitation to offer, I don't have any rights or remedies. I'm liable to pay the whole amount, right? Mr. Pratham applied for a job as a principal of a school. The school management decided to appoint him. One member of the school management committee privately informed. When, in case of a special offer, the offer can be accepted only by the person or group to whom it is made. Here, it is made to a group, school management committee. Who can accept it? Only the school management committee. The person privately communicating, is it a valid communication? No, it is not a valid communication, right? It is not a valid communication. Now, inform Mr. Pratham that he was appointed, but official and communication was not given from the school. Later, the management of the school decided, and it's given, official communication was not given. Later, the management of the school decided to appoint someone else as a principal. Mr. Pratham filed a suit against the school for cancellation of his appointment and claimed damages for loss of salary. Can he claim? No. The acceptance was never communicated. Since it was never communicated, there was no contract. So, no, he cannot. Will he be successful? No. Yes, correct, correct. A sends an offer to B to sell his second-hand car for 1,40,000 with a condition that if B does not reply within a week, he shall treat the offer as accepted. Bas ऐਵੇਂ ही? Huh? कुछ भी? How can you take my silence as acceptance? If I want to accept, I'll accept. Bhai, I have mouth to speak. I have hands to give gestures. How can you take my silence as acceptance, right? Is A correct in his proposition? No. No. The offer itself is not valid. What shall be the position if B communicates his acceptance after 1 week? The offer is not valid, so how can it be accepted? Correct? Acceptance, comment on the following. Acceptance must be absolute and unqualified. Yes, acceptance must be unconditional. If an acceptance is made, yes, exactly. That is the point, ready? Mere silence is not acceptance. If an acceptance is made conditionally, if the acceptance is conditional, it's just a counter offer, and counter offer does not result in the acceptance of the offer. Acceptance must be in the mode prescribed. If nothing is given, acceptance can be in any general mode. But if the mode is prescribed, then acceptance must be in the prescribed mode only. If it is not in the prescribed mode, it's not a valid acceptance. However, if it is not in the prescribed mode, but the other party accepts it, then it becomes a valid contract. Define the term acceptance under the Indian Contract Act. What are the legal rules relating to valid acceptance? Again, rules have to be given in details, okay? What is acceptance? When the person to whom the offer is made signifies his consent thereto. When the person to whom the offer is made signifies his consent thereto, he is said to have accepted the offer. What are the rules of acceptance? It must be absolute and unqualified. That is, it should be unconditional. Mere silence is not acceptance, but acceptance can be made by the conduct of the parties. Acceptance must be communicated, must be within the mode prescribed, and must be within the time specified. And if no time is specified, within a reasonable time. Correct? State the various modes of revocation of offer. Counter offer, cross offer. I'm expecting you all remember this. Yes, counter offer, cross offer. If it is, what do you say? If it is a specified mode is given and it is not in the mode prescribed, then if the time within which the offer should have been accepted lapses, then death or insanity and subsequent illegality. In all of these cases, the offer will lapse, right? Not going into too much of explanation. We have already done all those things when we were doing the revision class for the chapter. So yes, yes. And I'm very sure you will be able to write all of that. I'm not going into the detailing part. We had done it when we were doing the revision part. If you feel like, no, I just cannot study at all and I don't know what to do, just plug in your revision video and just go through it at, 2x speed. You will cover up the whole thing in that case. Yeah, and yes, by notice of revocation, which I forgot to say. Mr. B makes a proposal to Mr. S by a post to sell his house for 10 lakh and posted the letter on 10th of April 2020. And the letter reaches S on 12th April. He reads the letter on 13th April. Can we say communication of offer for A is 10th, B is 13th? Correct? I'm so sorry. I'm so sorry. For B it is 10th and for S it is 13th, right? Mr. S sends his letter of acceptance on 16th and the letter reaches B on 20th. If communication of acceptance was asked, for B it is 16th, for S it is 20th. Correct? Opposite. On 17th April, S changed his mind and sends a telegram withdrawing his acceptance. Telegram reaches B on 19th April. On 20th April, acceptance was received. 19th April, telegram was received. It's very obvious that revocation is valid. On which date the offer made by B will be complete? On 13th. If a specific date for reading was not given, then in that case the day I receive would have been the date. But otherwise a specific date for acceptance is given, then it is what? It is that specific date. Okay? Correct, Naseem. Correct. Then discuss the validity of acceptance. Can I say it is not valid because the revocation was received before the acceptance letter? Correct? What would be the validity of acceptance if the letter of revocation and reach together? So when revocation is made by a I'm so sorry, when revocation and acceptance both reach together, in that case there is no question about whatever he reads first. If both is received together, revocation is absolute. So what is valid? What is valid? Revocation. Yes, exactly, revocation is valid. Define consideration. State the characteristics of a valid so what is consideration? When at the desire of the promiser, the promisee or any other person had done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. Do you guys remember it? Are you able to recall it? What are the rules of consideration? First, consideration must move at the desire of the promiser. Consideration may move from the promisee or any other person. Consideration may be executed or executory. Consideration may be past, present, or future. Then consideration must be something which a promiser is not already bound to do. Consideration need not be adequate. And finally, consideration must not be unlawful, illegal, or against public policy. To form a valid contract, consideration must be adequate. Absolutely no. To form a valid contract, consideration must be present. However, there is no rule which says that give and take should be equal. Yeah, give and take should be there, but give and take need not be equal. Again, a contract cannot be cancelled on the grounds of inadequacy of consideration, right? Contract cannot be cancelled on the grounds of inadequacy of consideration. Yes, exactly, not equal, correct. Mr. Balwant, an old man, by a registered deed of gift, granted certain landed property to Miss Reema, his daughter. By the terms of the deed, it was stipulated that an annuity of 20,000 should be paid every year to Mr. Sawant, who was the brother of Mr. Balwant. On the same day, Miss Reena made a promise to Mr. Sawant. So there is one contract between Mr. Balwant and his daughter, Miss Reema, and there is another contract between Miss Rima and Mr. Sawant. On the same day, Miss Rima made a promise to Mr. Sawant and executed in his favor an agreement to give effect to the stipulation. Miss Rima failed to pay the stipulated sum. In an action against her by Mr. Sawant, she contended that since Mr. Sawant has not furnished any consideration, he has no right of action. If you remember the name of the case, Chenaya versus Ramaya, ma'am, I don't remember. It's okay if you don't. If you do, it's fine. If you don't, it's absolutely okay. In the case of Chenaya versus Ramaya, it was held that whenever consideration is given, even if the promisee is not giving any consideration, if the third party provides consideration, it's sufficient. The whole point is that consideration must be present. It is irrelevant who furnishes the consideration. Exactly. Consideration can move from the promisee or any other person. Right? It can move from the promisee or any other person. Correct? Now, moving to the next one. A stranger. I hope you people are able to no, this is not covenant running with the land. Murlidhar, this is not covenant running with the land. This is consideration may move from the promisee or any other person. Here, the third party is not a beneficiary. Rather, the third party there is a contract with the third party, and there is a contract between Miss Rima and Mr. Samant. There is a contract between them. Miss Rima is giving consideration, Mr. Samant is not giving any consideration. But Mr. Balwant, whatever his name is, has given consideration for this contract. A stranger, so I hope you are able to recall the points also. A stranger to a contract cannot sue. However, even in some cases, even a stranger can enforce the contract. The general rule is privity of contract. Only the parties to the contract can sue and be sued. Third party cannot sue. Correct? This is the general law. However, there are 7 lochas where a third party can sue. First, trust or beneficiary. If you are a beneficiary of a trust agreement, you can enforce the contract. Second, in case of marriage or family settlement, if a person is named as a beneficiary of a family, okay, Naseem, of a family or a marriage settlement, he can enforce the contract. Then the third one is in case of assignments where the rights of a contract are assigned to a third party, the third party can enforce the contract. Again, the fourth one, acknowledgement of liability or estoppel. I said 7 points. I'm sorry, it's 6. So when a third party acknowledges himself to be liable under the contract, then even if there is no contract with this third party can be sued. And in case of agents, any contracts made by the agents are enforceable by the principal. And finally, covenants running with the land. In case of covenants running with the land, if the purchaser of the land purchases the land which is subject to condition which he is aware of, then he is bound by those conditions. Mr. Sohanlal sold 10 acres of his agricultural land to Mr. Mohanlal on 25th September 2018 for 25 lakhs. The property papers mentioned a condition amongst other details that whosoever purchases the land is free to use 9 acres as per his choice, but since it's a, and also yes, it's a sale of land, but remaining 1 acre had to be allowed to be used by Mr. Chotelal. So can we say this is covenant running with the land? The contract is between Sohanlal and Mohanlal, where 1 acre of the land shall be given to Mr. Chotelal. Now on the 12th of October 2018, Mr. Sohanlal died, leaving behind his son and wife. Anyway, wife is life only. On 15th October, purchaser started construction of an auditorium on the whole of the 10 acres of land and denied any land to the son. Now, Chotelal wants to file a case against the purchaser and get a suitable redressal. Can he do that? Yes. He being the person to whom the benefits, I mean, the condition was that he is supposed to get 1 acre of land and Mohanlal is aware of this condition. It is his duty to fulfill. If he doesn't fulfill, C being the beneficiary has a right to enforce the contract, right? Moving on to the next one. No consideration, no contract. Obviously, a contract without consideration is void. लेकिन law में क्या होता है? लोचा. So here there are 7 lochas. First, natural love and affection. So when out of natural love and affection, parties stand in a near relation, enter into a contract and get it written and registered, it's a valid contract. The next one, compensation for past voluntary services. When a person voluntarily renders services for the promiser, the services have already been rendered, the promiser was in existence and he promises to pay, it's a valid contract. Time bar debt, a written promise to pay a time bar debt. So when the debtor or his agent authorized by him give a written promise to pay a time bar debt, it's a valid contract. Agency, when the agent, in case of agency, for the creation of agency, consideration may or may not be paid to the agent and it's still absolutely valid. Charities and donations, a promise to give charity is not enforceable, but if on the basis of the promise the other person has incurred any liability, he can recover to the extent of liabilities incurred. Completed gifts, a mere promise to gift is not enforceable, but once the gift is given, it's a valid contract. And finally, bailment. Consideration may or may not be present in a contract of bailment. Father promised to pay his son a sum of rupees 1 lakh if the son passed CA examinations in the first attempt. The son passed the examination in the first attempt, but father failed to pay the amount as promised. So, son files a suit for the recovery of the amount. State along with reasons whether the son can recover the amount. Can the son recover the amount? Can the son recover the amount? No. And why no? First, there is no consideration. Second, there is no legal relationship because it's between father and son. So it's just a domestic relationship, no legal relationship. But tell me, can I say if the contract was written and registered, would it be enforceable? Tell me, if the contract was written and registered, would it be enforceable? Yes, it would be. If the contract was written and registered, would it be enforceable? Yes, it would be enforceable. Mr. Ramesh promised to pay 50,000 to his wife Mrs. Lali so she can spend the sum on her 30th birthday. Mrs. Lali insisted her husband to make a written agreement and the agreement was registered. It was written and registered. In natural love and affection, if it is written and registered, it's valid. Mrs. Ramesh failed to pay the specified amount to his wife Mrs. Lali. Mrs. Lali wants to file a suit against Mr. Ramesh and recover for 50,000. She's going to... No comments. Can she succeed? Yes. In case of natural love and affection, when the parties stand in a near relation, enter into a contract, get it written and registered, it's a valid contract, right? Mr. Ramlal Birla was a big businessman of Pune of this. Mr. Ramlal Birla was a big businessman of city Pune, having 2 sons and 1 married daughter. He decided to gift his one house to his daughter. He decided to gift. Now, some people think, acha, gift, it's completed gifts. No. No. Completed gifts is like you make a promise to the other person that I will gift you. This is natural love and affection. He decided to gift his one house to his daughter. For this purpose, he called his lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of document, they met with an accident and both of them died. So registration of the document was never done, right? Yeah, there is a near relationship. It's made out of love and affection and it's made between parties who are in a relationship. It was written also, but it was not registered because when they were going for registration, both of them died. Exactly. Later, his daughter found the document and claimed the house on the basis of that document. Can she claim the house on the basis of the document? No, because it was never. If it was registered, could she claim? Just a second. Just a second. Let me just put my phone on laptop on charge. So as I was saying, if it was registered, could she sue to get that property? Yes, but since it was not registered, she has no remedies at all. Examine with reasons the given statement is correct or incorrect. Minor is liable to pay for the necessaries supplied to him. No, it's not correct. Not correct. A minor is never personally liable for the necessaries supplied to him. The liability is against the minor's property. Under quasi-contract, whenever a person supplies necessaries to a minor, he cannot sue. The minor is never personally liable to pay back for the necessaries. However, the person can recover the claim for the necessaries from the minor's property. Mr. Shekhar wants to sell his car. For this purpose, he appoints Mr. Nadan, a minor, as his agent. First of all, can a minor be an agent? Can a minor be an agent? Yes, a minor can be an agent. Mr. Shekhar instructs Mr. Nadan that the car should not be sold at a price less than 1 lakh. This was the instruction given. Mr. Nadan ignores the instruction of Mr. Shekhar gave the car to Mr. Nadan to sell it at 1 lakh. He sold it off to Mr. Masoom at 80,000. Is it a valid sale? Is it a valid sale? Yes, it's absolutely valid. A minor can be an agent and it's absolutely valid. Can he recover? Can Mr. S recover the loss from Mr. Nadan? No. No. You know, if Nadan was a major, no, we could have recovered the loss from Nadan. But since he's a minor, we cannot recover anything from him. Yes. Can Mr. Shekhar recover the car from Mr. Masoom? Can Mr. Shekhar recover the car from Mr. Masoom? No. The sale is absolutely valid. The sale is absolutely valid. Correct? Rahul, a minor, falsely representing his age, enters into an agreement with a shopkeeper for a loan amount falsely representing. When a minor fraudulently enters into a contract and the contract is cancelled, he can prove the fact that he is a minor. And the contract is discharged because a contract with a minor is void. But if the intention of the minor is to deceive, even if he proves his minority, he will have to compensate. Rahul, a minor, falsely representing his age, enters into an agreement with a shopkeeper for a loan amount for purchasing a laptop. He gave his expensive watch as a security and took a loan of 40,000. He was very happy and quickly went to the market and purchased the laptop worth 30,000 and spent the rest on a pleasure trip with his friends. सही जा रहा है बच्चा? Later on, Rahul realized that his watch was an expensive watch and he should not have given it like this to the shopkeeper. So he went back to the shopkeeper and asked for his watch back. Also, he refused to repay the loan amount. The shopkeeper disagrees to this and files a case against the minor for recovery of the loan amount. Can the shopkeeper succeed? Well, here the intention of the minor was to deceive. Now, when the minor's intention is to deceive, even if he returns the goods, even if he cancels the contract or proves his minority, he will have to compensate. Now, he will get his watch back, but he has to pay this money. Now, the money is not there. So, how will he pay the money? The money is not there, but 30,000 ka laptop is there. We can recover that 30,000 laptop from him. But this money, 10,000, which was spent on the pleasure trip, that obviously is not recoverable at all. Though a minor is not competent to contract, nothing in the contract prevents him from making the other party. An agreement with a minor is void. However, a minor can always be a beneficiary. Now, in every contract, when the minor is a beneficiary and he does not get his benefits, he has a right to go and enforce the contract against the other party. Shrishti, a minor, falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Gupta, owner of SP Laptops, for purchase of laptop on credit amounting 60,000 for purchasing a laptop on 1st August 2021. She promised to pay back the outstanding amount with interest at the rate of 16% per annum by 31st July. She told him that in case she won't be able to pay the amount, her father, Mr. Ram, will pay on her behalf. After 1 year, when Srishti was asked to pay the amount with interest, she refused to pay the amount and told the owner that she's a minor and now he can't recover a single penny from her. She will be adult on 1st Jan, only then the agreement can be ratified. So her intention is not to cheat. Though she is saying I am a major, her intention is not to deceive. By filing a case against the minor, can he recover the outstanding amount? No. By filing a case against Mr. Ram, can he recover the amount? Well, in this case, no. Why? The parent of a minor is only liable for the acts done with their authority. Here, it was nowhere given that Mr. Ram had authorized Srishti to go and buy the laptop, so he is not liable for the purchase. By filing a case against Srishti for recovery of outstanding amount after she attains majority, no. Why no? A Minors Act cannot be ratified. I hope it's clear to everyone. Ex a minor was studying in MCOM. Now, half of you will be thinking, how can he be studying in MCOM? That will be the doubt here, basically. Forget it, whatever they say. In a college, on the 1st of July, he took a loan of 1 lakh from B for payment of his college fees and to purchase books and agreed to repay by 31st December 2019. X possesses assets worth 9 lakh. So, he took a loan of 1 lakh for college fees. So, it's necessaries and he has assets of 9 lakh. Can we say we can recover this 1 lakh from this 9 lakh? Yes? Yes. So, decide whether B would succeed. Yes, he can recover the money from the other person. I was correct, no, Nikita? This doubt always arises. A student was induced by his teacher to sell his brand new car to the latter at less than the purchase price to secure more marks in the. Can we say this is undue influence? So, however, the father of the student persuaded him to sue his teacher. State on what grounds can you sue the teacher? On the grounds of undue influence. The contract is voidable. Discuss the essentials of undue influence. What is the essential? There should be a relationship. In case of a relationship, there should be a dominating position, right? Where one party is using this position to make contracts which are what? Unreasonable or unconcisable. Then we can say it is what? It is undue influence. And one more thing, when we say dominating position happens when there is a real or apparent authority, or when there is a fiduciary authority, or when there is mental distress, or when there are terms of the contract which are unconcisable or unreasonable. In any of these four cases, we can say that there is a dominating position. Correct? So the next question, explain the term coercion and describe its effect on the validity of the contract. Coercion is where one party threatens the other to enter into a contract by an act which is a crime or the unlawful detaining of the property of another. The force involved is a physical force and can be by or on a third party, right? Can be by or on a third party. What is the validity? In case of coercion, the contract is voidable. Now, when we say voidable, that means the aggrieved party can either cancel the contract or affirm the contract as per their choice. Explain the circumstances in which the person is deemed to be in a position to dominate the will of the other person. I already told you, when can you dominate the will? Real, apparent, mental distress, or no, mental or moral force is in undue influence, ready, not in coercion. Okay? Or mental distress or unreasonable or unconcisable terms. Define fraud, whether mere silence will amount to fraud. Fraud can be classified under 5 categories. The assertion of the fact which one believes to be true but makes the other person believe it to be false. Then contract entered without an intention to perform, active concealment of fact, any act declared fraudulent by the law, any act fitted to deceive. The essentials of fraud are that it must relate to the material fact and must induce the other party to contract. The general rule is that silence is not fraud. However, there are two cases where silence is considered as fraud, where it is the duty of the person keeping silent to speak. That is when the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silent to speak, or where silence is equivalent to speech, right? Karan agreed to purchase a wooden table for his study room from Mr. X. The table was in good condition and was examined by Karan. He examined it. He found no defects. That means, can we say Karan had carefully examined? Okay, ready. I thought you were talking about coercion. No problem, no problem. That means, can we say he was not negligent and paid 20,000 for that table? Later on, it was found that one leg of the table is broken and was pasted, and Mr. X had pasted the wood and tried to hide the defects. Now, you would say, but ma'am, he examined. No. So here it is very much evident that he examined it carefully, but he did not find the defect. That means it was not his fraud. Sorry, it was not his fault, but Mr. X had done fraud. So tell me, but if it was given, he casually examined, then he couldn't return. Here it is fraud. So discuss, can Karan return the table and claim the amount back? Yes. P sells by an auction to Q a horse which P knows to be unsound. The horse appears to be sound, but P knows about the unsoundness of the horse. In this, see, auction sale, silence is not fraud. I'm not required to tell you anything. You see, you like, you purchase. Is the contract valid in the following circumstances? If P says nothing about the unsoundness to Q, not required to say. He is not required to say. So the contract is absolutely valid. If P says nothing about it to Q, who is P's daughter who has come of age, that is, she's turned major. When it is a family person coming to auction, in that, generally in auction sale, I don't have to tell you anything. But it is my family coming to auction. It is the duty of the person keeping silent to speak. So here silence is what? Fraud. If Q says nothing to P, if Q says to P, if you do not deny it, I shall assume that the horse is sound. P says nothing. So here again, here it is what? It is voidable because it's fraud. Here can I say silence equals to speech? And when silence equals to speech, then silence is what? Fraud. It is what? Voidable. I hope it's clear to everyone. If see, I'm going at a speed, and obviously there is a latency also. So, but if you have any doubt in any of the questions, you will ask me immediately. Okay. Sohan induced Suraj to buy his motorcycle, saying that it was in a very good condition. After taking the motorcycle, Suraj complained that there were many defects in the motorcycle. Sohan proposed to get it repaired and promised to pay. So, first of all, he said that it was in a good condition, but Suraj complained that there were many defects in the motorcycle. So, this is fraud. Sohan proposed to get it repaired and promised to pay 40% of the cost of repairs. He says, I'll repair it and you pay me the cost. Now, we don't know what happened next, but if you see, after a few days, the motorcycle did not work at all. That means he accepted that 40%. Now Suraj wants to rescind the contract. Can he do so? No. Avoidable contract, once ratified, cannot be cancelled. Decide giving reasons. He cannot. He cannot rescind the contract. Avoidable contract, once ratified, cannot be cancelled. Right? Today I don't have my mobile to check your messages, so actually I'm not able to see your messages. It's like this distance to actually see the messages also. Kapil went to a departmental store to purchase a steel pan. He asked the salesman about the area in the departmental store. Just a second. Kapil went to a departmental store to purchase a steel pan. He asked the salesman about the area in the departmental store where the steel pan are kept. The salesman indicated him the area with the instruction that with steel pans, other metal pans were also kept. Other metal pans were also kept. Kapil wrongfully, he already told him there were other metal pans also. Kapil wrongfully picked up an aluminium pan in place of a steel pan. The salesman watched but said nothing to Kapil. Kapil, silence is not fraud. I'm not required to say anything at all. I have already told you that there the goods are, it's steel pans are mixed with other goods also. So I've already mentioned that. Kapil reached his house and found that the pan was not a steel pan but actually an aluminium pan. Kapil filed a suit against the store for fraud. Is it fraud? No. Silence is not fraud. Right? Silence is not fraud. Mr. X, a businessman, had been fighting a long drawn litigation with Mr. Y, an industrialist. To support his legal campaign, he enlists the services of Mr. C, a judicial officer, stating that the amount of 10 lakh would be paid to him if he does not take up the brief of Mr. Y. Can we say the object of this contract is unlawful? Yes or no? Can we say the object of this contract is unlawful? And since the object of the contract is unlawful, can we say the contract cannot be enforced? Since the object is unlawful, the contract cannot be enforced, right? It's void. So Mr. C agrees, but at the end of the litigation, he refuses to pay to Mr. X refuses to pay to Mr. C. Decide, can Mr. C recover the amount? No. The object is unlawful, so he cannot recover anything at all. Define misrepresentation and fraud. Fraud I already defined. What is misrepresentation? The positive assertion in a manner not warranted by the person making it, though which is not true, but he believes it to be true. Right? That is, I am stating something which I believe is true, but it is actually not true. Breach of duty, which without an intention to deceive the other person, gains advantage over the person by misleading him. We are not doing it with an intention to deceive. It is done unknowingly, but still I am gaining some advantage from the other person and causing, however, innocently to a party to make a mistake as to the substance of the thing. What is the difference? In fraud, it is the intention of fraud is to deceive, whereas in case of misrepresentation, the intention is not to deceive. Fraud, so when we say intention to deceive, fraud is intentional, misrepresentation is unintentional. In fraud, I can claim the damages. In misrepresentation, I cannot claim the damages. Concept of misrepresentation, we already know it. Chandan was suffering from some disease and was in great pain. He went to Dr. Junjunwala, whose consultation fees was 300. The doctor agreed to treat him on the condition that Chandan had to sign a promissory note of 5,000 payable to the doctor. He signed it and gave it to the doctor. On recovering from the disease, he refused to honor. Can we say here it is undue influence? Can we say it is undue influence, mental distress, so the doctor is dominating? Yes. So can he avoid? Yes, the contract is voidable at the option of Chandan. So when it is voidable at the option of Chandan, Chandan can actually avoid the contract. Mr. Y is a devotee and wants to donate an elephant to the temple as a core part of ritual worship. As a core part of ritual worship. He contacted Mr. X, who wanted to sell his elephant. Mr. X contracted with Mr. Y. Mr. X contracted with Mr. Y to sell his elephant for 20 lakh. Both were unaware that the elephant was dead a day before the agreement. Can we say mutual mistake? Can we say mutual mistake? Bilateral mistake? Yes or no? Yes. Keep writing the answers also. Keep thinking about the answers also. Right? Can we say it is void? Examine whether the contract is void, voidable or valid. Can we say it is void? Just let me switch on the fan. It's super hot. Just give me a minute. Okay, so moving on to the next one. Mr. Samant owned a motor car. He approached Mr. Chotu and offered to sell his motor car. Mr. Samant told Mr. Chotu that the motor car is running at the rate of 30 kilometers per liter of petrol. Both the fuel meter and the speed meter of the car were working perfectly. Mr. Chotu agreed with the proposal of Mr. Samant and took the delivery of the car by paying 3 lakh. After 10 days, he came back with the car and stated that the claim by Mr. Samant regarding the fuel efficiency was not correct and it was a case of misrepresentation. Well, it could have been misrepresentation, but they also say both the fuel meter and the speed meter were working perfectly. That means one party has used fraud or misrepresentation, but the other, if he would have used his diligence, would have come to know the facts. The contract is absolutely valid. Can Mr. Chotu return the car back? No. So, can he rescind the contract on the above grounds? No. The contract will be absolutely valid. Yes, whatever answers you are giving, it's absolutely correct. It's so good. You are able to answer, boosts up your confidence definitely. X agreed to become an assistant for 2 years to Y, who was a practicing CA at Jodhpur. It was also agreed that during the term of agreement, X will not practice as a CA on his own account within 20 kilometers of the office of Y at Jodhpur. At the end of 1 year, X left the assistantship of Y. Now here, it is given that for 2 years, see there are two things they have given. You are working for me, you cannot practice, and they have also given the time period of 2 years. Now he left the job after 1 year, but the contract said that for 2 years you cannot. So he started within this 20 kilometer. He started within that 2 years only. He started his own practice. So can we stop him? Yes. Any agreement in restraint of trade, if it is reasonable, it is valid. Here, since the restraint was reasonable, it's absolutely valid. So can the CA, practicing CA, stop him? Yes, he can stop him. An agreement, the meaning of which is, if the meaning of an agreement is uncertain, even if both the parties agree to it, it's void. However, if in a contract there is a vague term, but there are means to ascertain the vague term, the contract is absolutely valid. A enters into a contract with B that he sells his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling, then he will pay a rent of 50,000. B agreed to this. However, after a year of sale, B started gambling his business in that house. Can A claim 50,000? No. When a contract has two parts, right, one legal and the other illegal, the legal is valid, illegal is void. He can recover the purchase price, but he cannot recover the 50,000 because it is illegal. Correct? I hope you are following. No doubts. State with reason whether the following agreements are valid or void. A clause in the contract provided that no action. Every person has a right to take action. How can you stop me from taking an action? Such an agreement itself is void. Where two courts have jurisdiction, an agreement between the parties that the suit should be filed in one alone and not in the other is valid. We can have an agreement like we'll go to the arbitrator. It's absolutely valid. X offers to sell his Maruti car to Y. Y believes that X has only Wagoner car but agrees to buy it. Is it valid? No. They both are not talking about the same thing. There is a mistake about the identity of the goods. X, a physician, and surgeon, employs Y as an assistant on a salary of 75,000 per month for a term of 2 years, and Y agrees not to practice as a surgeon and physician during these 2 years. Is it valid? Yes. Any agreement in restraint of trade, if it is reasonable, it is absolutely valid, right? Rohan is running a grocery store in Delhi. He sells his grocery business, including goodwill, worth 1 lakh to Rohit for a sum of 5 lakh. After the sale of goodwill, Rohit made an agreement with Rohan. As per this agreement, Rohan is not to open another grocery store. Can we say this is in restraint of trade, that is for creation of monopoly? And any agreement which is for the creation of monopoly is what? Is void. Rohan is not to open another grocery store in the whole of India for the next 10 years. However, Rohan opens another store in the same city 2 months later. What are the rights available with Rohit regarding the restrictions imposed on Rohan with reference to Indian Contract Act? Can we say Rohit will have no rights at all? Can we say Rohit will have no rights? Oh, I am so sorry. I'm so sorry. I'm so sorry. He sold the goodwill of his business. Now, when I'm selling the goodwill of my business, can I say the buyer can actually restrict the seller from from doing the same business? I'm so sorry. Can he restrict the seller from doing the same business? Yes. But the restriction must be what? Reasonable. I'm so sorry. I literally zoned out. I don't know what happened. So, however, the restriction must be what? The restriction must be reasonable. If it is reasonable, it is valid. Now, Rohan, it is reasonable. Rohan opens another store in the same city 2 months later. Can we say Rohit can stop Rohan from doing it? Yes or no? I think I zoned out with this question. I created a blunder with this question, I guess. Can I just reread this whole thing again? The restraint was for the next 10 years. The restraint would have been valid, but giving it for 10 years is not valid. The restraint would have been valid, but the restraint for 10 years is not valid. Correct? Correct or not? I'm so sorry with this question. I literally zoned out. I'm super tired. I've been working since 7:30 in the morning. So, yes. So, can we say here, because of that, he cannot stop him because the restraint was unreasonable? Yes or no? I'm so sorry. So, coming on to the next one, Mr. S, aged 58 years, was employed in a government department. He was going to retire after 2 years. Mr. D made a proposal to Mr. S to apply for voluntary retirement from his post so that Mr. D can be appointed in his place. Mr. D offered a sum of 10 lakh as consideration to Mr. S in order to induce him to retire. Mr. S refused at first instance, but when he evaluated the amount offered is just the double of his cumulative remuneration to be received during the tenure of 2 years, he agreed to receive the consideration and the above agreement was accepted by him. Can we say this is sale of public offices, trafficking in public offices? Can we say this is sale of public offices, trafficking in public offices? Yes. So, what is the whether the above agreement is valid? No, the above agreement is what? It is void. Correct? What is a wagering agreement? An agreement to give money or money's worth on the happening or non-happening of a future uncertain event. Give examples of wagering transactions which resemble wagering but are not void. Chit fund, insurance, horse racing, then crossword competitions. If yes, yes, exactly. crossword competitions, then athlete competitions, they are all similar to wager, but they are not wager. What is the difference between wager and insurance? Wagering is to give money or money's worth on the happening or non happening of a future uncertain event, whereas insurance is to indemnify the loss. In wagering, there is no consideration, it's just gambling of money. But when I pay premium, I'm paying money, consideration. In wager, we don't have a pre estimation, just random anything we put. But in case of insurance, we actually make a pre estimation and then we put it. Yes, Murlidhar, correct. Shares, arbitrate mark, that is speculation, right? Then wager is void, whereas insurance is absolutely valid. Wagers are regarded as against public policies, whereas insurance is in the benefit of the society. Okay, explain the type of contracts in the following agreements under the Indian Contract Act. X promises to sell a scooter to Y for 1 lakh. However, the consent of X has been procured by Y at gunpoint. Can we say this is a voidable contract? Yes or no? They are asking you type of contract. A bought goods from B in 2015 but no payment was made till 2019. 15, 16, 17, 18, 19. Unenforceable because it's a time barred debt. G agrees to give tuitions to H, a pre-engineering student. When the laptop is crying. Believe me, you have not left me since morning. Everything is gone. I'll just start. It's gone. G agrees to give tuitions to H, a pre-engineering student, from the next month, and H, in consideration, promises to pay. Neither has G done nor has H done. So that means what? It is executory, right? It is executory. It is executory. Sheena was a classical dancer. She entered into an agreement with Sheetal Vidya Mandir for 60 dance performances. As per the contract, she was supposed to perform every weekend and she will be paid 10,000 per performance. However, after a month, she was absent without informing due to her personal reasons. Answer the following: whether the management of Sheetal Vidya Mandir has a right to terminate the contract. First of all, time is of essence. When time is of essence and one of the parties fails to perform, the contract is voidable. So, can they terminate? Yes. If the management of Sheetal Vidya Mandir informs Sheena about its continuance, can the management still rescind the contract after a month on this ground subsequently? No. A voidable contract, once ratified, cannot be cancelled. Once they have accepted it, they cannot cancel. Can they claim damages if suffered because of the breach in the above case? Well, if they cancel the contract, they have a right to claim the damages. If they accept the contract, they can claim damages only if it is mentioned. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract. Well, it is the duty of the promiser to perform the contract. In case of his inability to perform, or if he is not able to perform the contract as per the specified directions, then in that case he obviously has no right to ask the promisee to perform, because the promisee is liable to perform only after the promiser has performed. And in case one party, that is the promiser, refuses, the liability of the promisee to perform also comes to an end. Are you guys there? Are you following me? Now this Mr. X was a disc jockey. Same question. Same, perform every weekend. We have already done this question. Should I do it, or can we just skip to the next one? The basic rule is that the promiser must perform exactly what he has promised to perform. Obviously, whenever a contract is made, whatever are the terms of the contract, the person is bound to perform as per the terms of the contract. He cannot make any changes. He must perform the contract just as per its terms. If he tries to make changes to the contract, it's not a valid, it's breach, and the other party is not bound to accept it. A received certain goods from B, promising to pay 1 lakh. Later on, A expressed his inability to make the payment. C, who is known to A, pays 60,000 to B on behalf of A. However, A was not aware of the payment. Now, B is intending to sue A for the amount of 1 lakh. Can he do so? No, because a third party can also perform the contract. And when the third party performs, it's absolutely valid. Is the contention of B right? No. He cannot sue him for the whole amount. Decide with reasons whether the following agreements are valid or void under the provisions of the Indian Contract Act. Vijay agrees with Seni to sell his black horse for 3 lakh. Unknown to both the parties, the horse was dead. It's void because it's bilateral mistake of fact. Sarvesh sells the goodwill of his shop to Vikas for 10 lakh and promises not to carry the business forever and anywhere in India. Obviously, it is in restraint of trade and hence it's void. Mr. X agrees to write a book with a publisher. After a few days, he is dead. Supervening impossibility. I cannot ask his legal heirs to perform because it's personal skill. State the grounds upon which a contract may be discharged. A contract can be discharged by 6 different ways. First, by performance, which can be actual or attempted. By lapse of time, time-barred debt. By operation of law, mergers, insolvency, death. By mutual consent, novation, rescission, remission, and alteration. Then, by impossibility of performance, which can be existing at the time of contract or supervening impossibility. And by breach. Breach can be actual or anticipatory. An anticipatory breach of contract is a breach occurring before the time fixed for performance has arrived. Discuss it, stating the effect. So when prior to the due date, one party comes to know the other will not perform, it is anticipatory breach. The aggrieved party has two options. He may either cancel the contract on that very day or wait till the due date. If he cancels the contract on that day, he can claim damages. But if he waits till the due date, that is, he by words or actions makes it believe that no, I'm going to wait. So in that case, if on the due date the other party performs, he is bound to accept. If the other party does not perform its actual breach, he can cancel and claim the damages. Point out with reasons whether the following agreements are, I should have kept my hand gloves. Whether the following agreements are valid or void. Kamla promises Ramesh to lend 5 lakh in lieu of consideration that Ramesh gets Kamla's marriage dissolved and he himself. Agreement and restraint of marriage is against public policy and hence void. Sohan agrees with Mohan to sell his black horse. We have already done. Unknown to both the parties, the horse was already dead. Void. Ram sells the goodwill and this we have already done. Void. In an agreement between Prakash and Girish, there is a condition that they will not institute legal proceedings against each other without consent. Void. Every person has a right to go to the court. Any agreement which stops the person from going to the court is void. Ramamurthy, who is a citizen of India, enters into an agreement with an alien friend. Absolutely valid. Alien friend I can enter. Alien enemy I cannot. Mr. S. Answer the following. Mr. S and Mr. R made contract wherein Mr. R agreed to deliver paper cup manufacturing machine to Mr. R and to receive payment on delivery. On the delivery date, Mr. R didn't pay the agreed price. Decide whether S is bound to deliver. No. Where in a contract one party refuses to perform, the other is not bound to perform. Mr. Y gave loan to Mr. G, 30 lakh. Mr. G defaulted in the loan on the due date and the debt becomes time barred. After the debt is time barred, G agreed to settle the full amount to Y. Whether acceptance of time barred debt is valid and enforceable. Well, if it is a written promise to pay a time barred debt, it's enforceable. However, if it is an oral promise, it's not valid. A and B entered into a contract to supply unique item, alternate of which is not available in the market. A refused to supply. It's unique item. If you refuse to supply, damages are not adequate. So I will sue you to perform the contract. Specific performance. Mr. X promised to bring back Mr. Y to life again. Wow. No one would be dead then. A agreed to sell 50 kgs of apple to B. The loaded truck left for delivery on 15th March, but due to riots in between reached on 19th. Well, supervening impossibilities, destruction of subject matter, perishable goods, they would never survive 5 days of delay. Contract is void. An artist promised to paint on the fixed date, but met with an accident and both his hands were lost. Void, because personal skill. Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation of both the countries, the imports from China were banned. Void, because of supervening impossibility. This we have already done, this we have already done, this we have already done, this we have already done. So I'm not going into this again. A, B, C and D are 4 partners in a firm. They jointly promised to pay 6 lakh to F. B and C have become insolvent. B was unable to pay any amount and C could only pay 50,000. A is compelled to pay the whole amount. Decide to what extent can he recover. Now, they have promised 6 lakh. They will pay 6 lakh. So, each of them is liable to pay how much? 1,50,000. A and D both will pay how much? 1,50,000 their share. Now, B was unable to pay any amount. So, his loss of 1,50,000 will be divided between them in their proportion, that is equally, because equal is the ratio. C has paid, C is willing to pay, C is able to pay 50,000. So, out of 1,50,000, C is paying how much? 50,000. So, what is the loss? 1 lakh. Who will bear this loss? A and D. How much? 50,000 each. So each of them is liable to pay how much? 2,75,000. So how much can he recover from D? 2,75,000. I hope you are following. X, Y and Z jointly borrowed 50,000 from A. The whole amount was repaid to A by Y. Decide, can Y recover the contribution from X and Z? Yes. Are the legal representatives of X liable in the case of death of X? Yes. Can Y recover it from Z asset if he becomes insolvent? If the assets are sufficient, yes. If the assets are not sufficient, then X and Y will bear the loss. Ajay, Vijay and Sanjay are partners in a software business and jointly promised to pay 6 lakh to Karthik over a period of time. So each of them is liable how much? Sorry, I'm so sorry. Each of them is liable for how much? 2 lakh. Over a period of time, Vijay becomes insolvent, but he can only pay 1/4 of his debts. That means how much will he pay? 50,000. That means what is his loss? 1,50,000. How much will each of them bear? 75,000 each. Sanjay is compelled to pay the whole amount. Decide whether Sanjay is required to pay the whole amount. Yes, we can hold any one of them liable because there is a severe liability. Mr. Sonumal, a wealthy individual, provided a loan of 80,000 to Mr. Datumal on 26/2/2019. The borrower, Mr. Datumal, asked for a further loan of 1,50,000. Mr. Sonumal agreed but provided the loan on different days. 1 lakh on 28/2/2019 and 50,000 on 3/3/2019. On 10/3/2019, Datumal, while paying off part 75,000 to Sonumal, insisted that the lender should adjust 50,000 towards the loan taken on 3/3/2019 and balance as against the loan of this 26, that is this money. Mr. Sonumal objected to this arrangement. Well, when the debtor is making the payment, the debtor has a right to decide which debt to set off. And if the creditor accepts the payment, has to set off that debt only. So Mr. Sonumal cannot object. So whether the contention of Mr. Datumal is correct? Yes. What would be the answer in case the borrower does not insist on such order? In that case, Mr. Sonumal can decide which debt to set off. What would be the mode? If both do not specify, then in that case, chronologically, whichever is first will be set off first. Mr. Murari owes payment of 3 bills to Mr. Girdhari. Mr. Murari made a payment as below without any notice of how to appropriate. Since this amount and this amount is same, we will adjust this amount against this. This is implied specification. The rest 15,000 can be adjusted against the two debts, right? Preferably this is time barred, set this off first and then remaining from here. Mr. Jhoot entered into an agreement with Mr. Such to purchase his motor car for 5 lakh within a period of 3 months. A security amount of 20,000 was also paid by Mr. Jhoot to Mr. Such in terms of the agreement. After completion of 3 months of entering into the agreement, Mr. Such tried to contract Mr. Jhoot to purchase the car. Even after lapse of another 3 months, Mr. Jhoot neither responded to Mr. Such nor to his phone calls. After lapse of another 6 months, Mr. Jhoot contracted and denied to purchase and asked for the refund. Well, first of all, the refund to kya? You are the one who are dealing. You shouldn't get refund only. Second, this was not a benefit, but it was a security deposit, and a security deposit is not refundable. So, he cannot ask for the refund. However, what would have happened if the motor car would have been destroyed by an accident within 3 months period? If within this 3 months only the motor car was destroyed, then it would be supervening impossibility and then he would have to return the money back. Enumerate the person by whom a contract may be performed. Promiser himself, his agent, his legal heirs, third party or joint promisers. Mr. Singhania entered into a contract. We have already discussed this. I am not going. Just one thing. What would be your answer in case he sends Mr. Mika in his place? So basically Mr. Sonu was engaged to sing. One night he did not come, but he sent Mr. Mika in his place. Am I bound to accept Mr. Mika's performance? No. But Mr. Singhania allowed him to perform. So he has accepted. So when he has accepted, the contract becomes what? Valid. Explain any 5 circumstances where the contract need not be performed with the consent of both. Novation, cancelling the old contract, making a new one. Rescission, cancellation of the contract. Alteration, change in the terms of the contract. Remission, acceptance of a lesser amount in full and final settlement or acceptance of kind in place of cash. And waiver, where both the parties mutually decide not to perform, give up their rights. State the grounds upon which a contract may be discharged under the provisions of the Indian Contract Act. We have already discussed this question. Explain what is meant by supervening impossibility and with the help of an example. When subsequent to the formation of the contract, any event happens which makes the performance impossible, making the contract void, the contract is discharged by supervening impossibility. In the case of supervening impossibility, the aggrieved party shall have no right to claim damages. However, if any benefit has been received, shall have to be returned back. 5 cases: outbreak of war, change in law, death of promisor, non-existence of a particular state of thing, destruction of subject matter. In your institute's material, they have not given any headings. So it's okay if you don't even remember the headings, just examples are enough. I have given you the heading so that you know that nothing other than this is supervening impossibility. Examine the validity of the following contract. X, aged 16 years, borrowed a loan of 50,000 for his personal purpose. Few months later, he had become major and could not pay back. The lender wants to file a suit. Not valid. Cannot sue because he's a minor. J contracts to take in cargo for K at a foreign port. J's government afterwards declares war. Khatam. Void. Supervening impossibility. Correct? Supervening impossibility. Wow, we are nearing the end now. Very good. An anticipatory is a breach. Oh, we have already done this. He has two options, cancel or accept. Mr. Rich aspired to get a self-portrait made by an artist. He went to the workshop of Mr. C, an artist, and asked whether he could sketch the former's portrait, an oil painting canvas. Mr. C agreed to the offer and asked 50,000 as full advance payment for the above creative work. Mr. C clarified that the painting shall be completed in 10 sittings and shall take 3 months. On reaching the workshop for the 6th sitting, Mr. Rich was informed that Mr. C has become paralyzed and would not be able to paint for the near future. Mr. C had a son, Mr. K, who was still pursuing his studies and had not taken up his father's profession yet. Can Mr. Rich ask Mr. K to complete the artistic work in lieu of his father? No. Could Mr. Rich ask Mr. K for the refund of money paid in advance to his father? Yes, restitution can happen. But you cannot ask him because it's personal skill. What is the law relating to determination of compensation? Any damage which arose naturally can be claimed, but special damages can be claimed if only there is a notice. Further, any damage which is indirect or remote cannot be claimed under any situations. Vindictive or exemplary damages, they are punitive in nature and not awarded in any case unless two cases. First is wrongful dishonor of a customer's check, and second is breach of contract of marriage. A businessman check is dishonored, it would automatically cause loss of reputation without doubt. But any other person's check dishonored, loss of reputation has to be proved. Liquidated damage is a genuine pre-estimate, whereas penalty is an extravagant amount. In some cases, the parties may actually mention the damages that would be claimed in case of breach. Where the parties have mentioned the damage that can be claimed, that becomes the ceiling limit, and the aggrieved party can claim the amount mentioned or suffered, whichever is less. When the parties try to figure out and calculate the probable damage that they may suffer, it is liquidated damage. But when they mention a very high amount as damage, which is nowhere near to the actual damage, it's penalty. Whatever is mentioned, you will only get what you have suffered. But in case of government contracts, the government, in case of breach, the government has a right to claim the penalty mentioned. Mr. X and Mr. Y entered into a contract on 1st of August by which Mr. X had to supply 50 tons of sugar to Mr. Y at a certain price, strictly within a period of 10 days of the contract. Mr. Y also paid an amount of 50,000 towards advance as per the terms of the above contract. The mode of transportation available between their places is roadway only. Due to severe flood, he could not, supply the goods. Within 15 days, Mr. X offered to supply the sugar on 20th August, for which he did not agree. So because he did not get the goods at that time, he could have disagreed later. It's absolutely okay. Mr. X claimed compensation of 10,000. It was something which was beyond the control of any party. And since the time had lapsed, he has a right to refuse to take the delivery. So he cannot claim any compensation because this is not breach of contract. Later and further, Mr. Y asked for the refund of the 50,000. Can we ask for the refund? Yes, in case of any impossibility of performance, we have a right to claim the money back. PM Limited contracts with Gupta traders to make and deliver certain machinery to them by 30th June 2017 for 21 lakh 50,000. Due to labor strike, PM Limited could not manufacture and deliver the machinery. Later, Gupta brothers procured the machinery from another manufacturer for 22.75 lakh. Gupta Trader was also prevented from performing a contract which it had made with Zenith traders at the time of their contract with PM, and were compelled to pay compensation for breach of contract. Calculate the amount of compensation. Obviously, 1.25 lakh can be claimed. As far as the loss to sale to sale to Zenith is concerned, if they had mentioned this to PM, they could have claimed this damage also. But if it is not mentioned, they cannot claim because it's a special damage. Mr. Murthy was traveling to Manali with his wife by a bus. Due to some technical default in the bus, the driver had to stop the bus in a midway in cold night. Driver advised the passengers to get the shelter in the nearest hotel, which was at a distance of 1 kilometer. The wife of Mr. Murthy caught cold and fell ill due to being asked to get down, and she had to walk in cold night to reach the hotel. Mr. Murthy filed a suit. They can for damages for personal inconvenience, hotel charges and medical treatment. This and this he will get, but medical treatment is a remote damage. Because the bus did not work, for which you had to walk, for which you had cold, it's very remote and cannot be claimed. Seema was running a boutique. In New Delhi. I hope you guys are there with me. In New Delhi, she had to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. Seema delivered the sewing machine and some cloths to the railway company to be delivered where the exhibition was to be held. She expected to earn an exceptional profit from sales made at the exhibition. However, she did not bring this fact to the notice of the railway authorities. Can she claim the special damages? No. Can she claim the loss of profits? No, because the special notice was never given. X entered into a contract with Y to supply him 1,000 water bottles at rupees 5. Thereafter, X contracted with Z for purchase of water bottles at 4.5. And he also told Z that he did so for the purpose of performing his contract with Y at rupees 5. Z did not supply and the market price went up to 5.25. Can he claim damages? Now, in the first case, since he told Z that I am going to sell them to Y at 5 rupees, the damage is how much? 0.50, which he can claim. But if he would not have told him about this contract price is 4.5, market price is 5.25, he can claim 7.25. Okay. If you have doubts, you can ask me, please. What do you mean by quantum Marriott? State the cases. As much as is earned or as much as is merited. If a contract is separable and a part is performed, payment shall be made for the part performed. If the contract is not separable and a part is performed, no payment shall be made. But if the other party accepts it, he has to pay for the part accepted. A coolie in uniform picks up luggage of R to be carried out of the railway station without being asked by R, and R allows him to do so. Quasi-contract. Work done non-gratuitously. When a person does the work for another, not intending to do it gratuitously, and the other person enjoys it, he must pay for the work done. Right? What is quasi-contract? What are the circumstances which are identified as quasi-contract? There is no contract between the parties, but a contract is created by law. There are 5 types of quasi-contract. Claim for necessary supplied to a minor or to a lunatic's family. Payment made for a third person. Work done non-gratuitously. Responsibility of finder of the goods. And claim goods delivered by mistake or under coercion. What is meant by quasi-contract? State any 3 salient features. So what is quasi? We have already discussed. State any. It is made to prevent the unjust enrichment of one at the expense of other. It is generally a right to money or any other thing which can be expressed in terms of money, and it is a right against a specific person and not the world at large. What are the types of contract in the following cases? Coolie picks up we just discussed this, quasi. Obligation of finder of the goods, quasi. A contracts with B for supply of 10 tons of sugar, but before the supply, the fire caught in the factory and everything was destroyed. Void. Supervening impossibility, right? X found a wallet in a restaurant. He inquired of all the customers present there, but the true owner could not be found. When he handed over the same to the manager of the restaurant to keep till the true owner is found. After a week, he went back to the restaurant to inquire about the wallet. The manager refused to return him. The finder of the goods has the right of ownership against the whole over the goods against the whole world except the owner. If the owner comes and claims the wallet, X has to give. But if the owner does not claim, X has a right over the wallet. So he can recover it from the manager. Yes, he can recover it from the manager. PQR, a hospital in Delhi, recruits Dr. A on a contract basis for a period of 3 months. The hospital management promises to pay Dr. A a lump sum amount of 1 lakh if Dr. A tests positive for novel coronavirus during the period of 3 months. What is the type of contract? Contingent contract. What are the rules of enforcement? This is dependent on the happening of an event. If he contracts the virus, he would be paid. If he does not contract the virus, he will not be paid. Also, what will happen if he does not contract COVID-19? He will not get the money. What is contingent contract? What are the rules? State what is contingent contract? To do or not to do something on the happening or non-happening of a future uncertain event. The characteristics are the event is an uncertain event. It must be a collateral event that is not a part of the reciprocal promises, and it does not depend on the will of the promiser. Contingent contract dependent on the happening of an event is valid when the event happens, becomes void when the event does not happen. Contingent contract dependent on the non-happening of an event is valid when the event does not happen, becomes void when the event happens, or does not become impossible. Then contingent contract dependent on a third person is valid if the third person acts accordingly, void if the third person does not act accordingly. And if it is dependent on an impossible event, it is void ab initio. So with this, we have covered Indian Contract Act, and I hope this session helps you. And just a few pointers before the exam. Read the question paper thoroughly before you start writing the paper. Be very sure about the answers you're going to write. Start with the answer that you're very sure about. Gives you two things, confidence and time saving. If you are not able to answer any of the question, don't waste your time thinking about it. Skip it. Come back to it at the end again. Don't waste too much of time that then as is required to solve that question. Just please skip to the next one. And most importantly, be calm, believe in yourself. You are the best. You have put in so much effort since the past few months. You deserve to have a rocking paper. So let your paper be as rocking as you are.